Professor Young introduce our speaker for today.
Well, thank all of you for coming. It's very good to be able to introduce Randy Barnett, who is the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center. Randy's done a lot of things in his career. He's been a prosecutor as well as a professor. He insisted last night at our seminar meeting that he should not be introduced as a libertarian constitutional theorist. He is a leading constitutional theorist who happens to be a libertarian but would never, ever consider allowing his substantive views to infect his constitutional interpretation. Professor Barnett's, one of his most recent exploits was to argue the medical marijuana or medical cannabis case of Gonzalez versus Raich in the Supreme Court. One of the concerns I remember in trying to help Professor Barnett prepare for that argument was that he needed to convince the court that although he wanted them to impose a limit on national power under the Commerce Clause in much the same way as has been done by the court prior to 1937, that he was not advocating anything like a return to the Lochner era. So it's particularly fitting that I introduce Professor Barnett to speak about why Lochner was in fact rightly decided.
Well, thanks, Ernie. I wasn't actually arguing anything that would harbinger the return to the Lochner era in reality. It was just a little teeny minor application of prior case law to a perfectly uncontroversial case before the court. That's all it was. That's all it would have been. Anyway, it's a very great pleasure to be here. I have to say one reason I'm a few minutes late is I drove right past the law school without recognizing it. I've been here before, and I just had no idea this was the law school. So it's really, really spectacular. What a spectacular! Many of you probably don't even know what the law school used to look like. But this is just an amazing facility, and so anyway, it's understandable why I wouldn't have recognized it and drove right past it. So I am here now, and I want to get going because I know some of you are going to have to leave for class. What is it, like 1:10 or something like that? So let me just get into this. This is a talk that's about Lochner, and just to take a show of hands, how many of you have had constitutional, I don't know when constitutional law here is taught here at Duke, how many of you have had constitutional law? Right. In constitutional law class, how many of you have heard about Lochner? Okay, so that's good. Well, let me just see if I can put into a single word what you were taught about Lochner. And let me see what that word might be. How about this? See if this isn't an accurate characterization of what Lochner is in a single word. Lochner is bad. Okay? Does that seem like it accurately characterizes your takeaway? What's the takeaway? Lochner is bad. Yeah, Lochner is bad. Lochner is part of what Jack Balkin calls the anti-canon. We have the canon of the cases that all constitutional theories must say were rightly decided, and then we have the anti-canon of all the cases that your constitutional theory must say are wrongly decided if your constitutional theory is to have validity. So that's the degree to which Lochner is bad. It's canonically bad. But actually, Lochner's stature as a case in the anti-canon is better than it used to be. Because it used to be, when Lochner was taught, Lochner was very bad. And now it's moved from very bad to just being bad. So what happened? Why was it very bad? Well, it was very bad because it did two things that were bad, not just one. Now it just does one thing. And what were the two things? Well, the first thing it did was it employed a doctrine called substantive due process. And substantive due process was considered to be bad. Now, the court never called what it was doing substantive due process. It just said it was using the due process clause, or it'd be a violation of due process to do X, Y, and Z. It never used the word. The term substantive due process was a term of opprobrium that was formed by progressive critics of the Supreme Court who didn't like what the court were doing, and they labeled what the court was doing substantive due process because it seemed like a kind of a ridiculous concept to do substantive due process. So the label itself was an act of ridicule, kind of the way the Federalists labeled opponents of the Constitution anti-Federalists. It's not that they called themselves anti-Federalists, but they were called anti-Federalists. And then, of course, the opposite of substantive due process is procedural due process, and that's ridiculous because it's so redundant, right? So they came up with this term. Well, nowadays, something happened to substantive due process, and one of the things that happened to substantive due process was Griswold versus Connecticut, in which the due process clause is being used to protect a right of privacy, and that's considered by many law professors to be a good thing. And then happened Roe versus Wade, substantive due process used to protect a right of privacy, and many law professors, I would say many law professors think that that's a good thing. And so now, if those are good things, and other things like substantive due process are good things, then Lochner can't be bad because it employs substantive due process. That can't be what the problem is. So what is the problem with Lochner? Well, Lochner not only employed substantive due process, it employed substantive due process to protect the liberty of contract. So then what makes Lochner bad is not that it used substantive due process, but it used substantive due process to protect the wrong kind of liberty or the wrong kind of right, economic liberties or contract liberties there. So that's why Lochner is only bad and not very bad. So in my talk today, I want to talk about whether it is improper to use the 14th Amendment to protect economic liberties, the kind of liberties that are protected by the court in Lochner. Because if that's not bad, then the only thing that could conceivably be wrong with Lochner is that it inaccurately evaluated the statute as to whether it really did violate liberty of contract, which is kind of Justice Harlan's dissenting opinion, saying it didn't violate the liberty of contract. He didn't deny there was a liberty of contract like Holmes did, but he thought it was wrongly decided. The case could still be wrongly decided on its facts, but not because it was protecting economic liberties. So I'm going to make a brief case for why it is that the 14th Amendment does protect economic liberty. And the case I'm going to make is largely unknown to law professors. It's not the sort of thing that they've really heard before. Although there are historians who know many of the facts I'm talking about, law professors haven't really incorporated those facts into their views of the 14th Amendment. And one of the reasons why this story is unknown is because it doesn't start with the 14th Amendment. It actually starts with the 9th Amendment. And I'm sure you've spent weeks studying the 9th Amendment in your law school class, and so you've committed it to memory, and therefore you know that the 9th Amendment says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. I'm just kidding. I know you didn't spend weeks on the 9th Amendment. I don't spend weeks on the 9th Amendment when I'm teaching it, even though I kind of like the 9th Amendment. So that's what the 9th Amendment says. And let me just talk a bit. I'm going to talk a bit about the 9th Amendment, and then I'm going to go and I'm going to talk about the 14th Amendment. So that's kind of how this talk is going to go. So if you've read the 9th Amendment, you've heard the 9th Amendment, you might have looked at it like I did when I was a law student and said, boy, that sounds pretty good. Wow, I had no idea the Constitution said that. Wonder what that means. And then the first question you're going to ask, and for some people it's the last question they ever ask, and that is, well, what are these rights retained by the people? What do they mean by rights retained by the people? Well, the evidence is pretty overwhelming that the term rights retained by the people is a reference to natural rights. Natural rights. So in order to appreciate some of that evidence, I'm going to tell you about a particular passage from an amendment that was drafted by Representative Roger Sherman in the House of Representatives. So Madison proposes to the House that there should be a Bill of Rights. They he does so repeatedly. The House isn't all that interested in the idea, but they eventually form a committee. They let Madison be on it. Sherman's on it too. Madison's original proposal was that the Constitution be literally amended in the sense that things were going to be crossed out, reinserted, passages are going to be put in different places. That's what he thought amending the Constitution was. Kind of interesting. We take for granted it's not like that. Well, it's thought that Roger Sherman on the committee was one of the guys who thought that really the amendments ought to go as a list at the end. And so we in the 1980s was discovered this list of rights amongst Madison's papers, which were identified as Sherman's in the 1980s by his handwriting, and we think this was the list of rights. He translated Madison's proposal and what they were discussing on committee into a list that would be attached to the end. So this is his list. This isn't even a list he necessarily favored. Some people say that Roger Sherman didn't even believe in there being a Bill of Rights. So I'm not arguing that this is something Sherman was for, but what I think is very significant is the wording that Sherman used in this, what is his Second Amendment. And here's how his Second Amendment begins. The people have certain natural rights which are retained by them when they enter into society. The people have certain natural rights which are retained by them when they enter into society. In this passage, Sherman uses all the terminology eventually employed in the Ninth Amendment: the people, rights, and retained. And the rights retained by the people are then explicitly characterized as natural rights. Sherman's proposal then ends with the following injunction: of these rights they shall not be deprived by the government of the United States, which tells us something about what deny or disparage might mean in the Ninth Amendment. But what was meant by natural rights? So if, in fact, it's true that the rights retained by the people is a way of expressing the idea of natural rights, then what was meant by natural rights? What does that mean? Well, in the middle of Sherman's draft, he provides examples of natural rights. And they're only examples because the list begins, such are. And let me just tell you what he gives as his examples of natural rights. Such are the rights of conscience in matters of religion, of acquiring property, and of pursuing happiness and safety, of speaking, writing, and publishing their sentiments with decency and freedom, of peaceably assembling to consult their common good, and of applying to government by petition or remonstrance for redress of grievances. Okay, that's what he thought. Now, some of these natural rights were included in the Bill of Rights, particularly in the First Amendment. Although that was true, the right of acquiring property and of pursuing happiness and safety were not included in the Bill of Rights. These remained unenumerated rights retained by the people. They were rights retained by the people before, and they're rights retained by the people still. Now, Sherman's rendition of natural rights, this rendition of natural rights, was extremely commonplace. It was not idiosyncratic at all. And now I want to establish that. And the only way to establish that something is commonplace is by reading you lots of examples of it. So that's what's coming, all right? So first, let's begin with a proposed amendment in the Senate. After the Bill of Rights is sent to the Senate, the proposal was sent to the Senate, other proposals are made, and this is something that was proposed but not adopted in the Senate, that there are certain natural rights of which men, when they form a social compact, cannot deprive or divest their posterity, among which are the enjoyment of life and liberty, with the means of acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. Sounds a lot like Sherman's draft, only doesn't use the word retained. This is why I start with Sherman's draft. Similar proposals are proposed by state ratification conventions after the Federalists promised that they would enact a Bill of Rights in the Congress if people would ratify the Constitution as it was. State ratification conventions started proposing, accompanying their ratifications with proposals that they wanted be added to the Constitution. Here's Virginia's first proposed amendment: that there are certain natural rights of which men, when they form a social compact, cannot deprive or divest their posterity, among which are the enjoyment of life and liberty, and with the means of acquiring, possessing, and protecting property, and of pursuing and obtaining happiness and safety. Okay? From New York came the following proposal. It is a little different: that the enjoyment of life, liberty, and the pursuit of happiness are essential rights which every government ought to respect and preserve. Many state constitutions contain similar language as well. Here's Massachusetts. All men are born free and equal and have certain natural, essential, and unalienable rights, among which may be reckoned the right of enjoying and defending their lives and liberty, and of acquiring, possessing, and protecting property. In fine, that of seeking and obtaining their happiness and safety. New Hampshire. All men have certain natural, essential, and inherent rights, among which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and in a word, of seeking and obtaining happiness. New York. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, among which are these are life, liberty, and the pursuit of happiness. Pennsylvania. That all men are born equally free and independent, and have certain natural, inherent, and unalienable rights, among which are the enjoying and defending of life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. And finally, Vermont. That all men are born equally free and independent, and have certain natural, inherent, and unalienable rights, among which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. Okay, what does this tell us? It tells us a lot of things. First of all, it tells us that the rhetoric of natural rights survived the Revolution. There are some historians who have said that the revolutionaries were big on unalienable natural rights and the Declaration of Independence, but that was all revolutionary rhetoric. By the time they got around to drafting a constitution after their experience with the Articles of Confederation, they were a lot more conservative, they were a lot more interested in government, they were a lot more Blackstonian, and they were a lot less Lockean. And at this point, the Declaration had kind of fallen behind the wayside. You can see that is just not true. You can see that they continued insistence on the pursuit of happiness and the natural rights that all people have, the natural and inalienable rights that all people have. That's number one. Number two, you can see that they thought that that the rights retained by the people, which are the natural rights, is not a creature of federal government. It's not something that's just left over that's not some after effect of creating a federal government of enumerated powers. These are rights that apply to state governments as well. These are rights that are in state constitutions that are supposed to be limiting state power. Natural rights are rights that people have against all government, not just the federal government, but state governments as well. And all these provisions share in common the affirmation that the natural and inherent and inalienable rights retained by the people include the right to acquire and possess and protect property, as well as the right to pursue happiness. Now today, we would consider the right to acquire, possess, and use property as an economic liberty, while the right to pursue happiness we might call a personal liberty. But this distinction between economic and personal liberties is entirely anachronistic when applied to the founding, when these unenumerated natural rights were considered inextricably intertwined. Indeed, as the Massachusetts and Vermont constitutions suggest, the right to acquire, use, and possess property was a vital means to the pursuit of happiness. The two are actually linked in that way. But the last sentence of Sherman's draft is also evidence that the Bill of Rights as a whole, and the Ninth Amendment in particular, was a limitation on federal as opposed to state power. Remember what it says? It says, "Of these rights, therefore, they shall not be deprived by the government of the United States." What of the states? Well, it's important to note that Article 1, Section 10 does bar states from making any law any law impairing the obligation of contracts. So that kind of economic right is right in the original Constitution. But in the case of Barron versus Baltimore, how many of you have had Barron versus Baltimore? Not that many. Raise your hand. Okay, not that many. It's funny. I asked this yesterday at UNC, and like nobody raised their hand. So Barron versus Baltimore didn't make it into whatever the course was that was being taught. In Barron versus Baltimore, the Supreme Court denied that the takings clause of the Fifth Amendment applied to the states in federal court. That was a case in which Baltimore had taken some land, or allegedly taken some land, without just compensation. The property owner pled the Fifth Amendment, and the Supreme Court said the Bill of Rights does not apply to the states in federal court. You can't enforce the Bill of Rights against a state in federal court. Now, whether or not that was a correct reading of the Bill of Rights, and Roger Sherman's draft is part of the evidence that suggests that it was a correct reading of the Bill of Rights. That came to be the prevailing doctrine, and it's against that doctrine we have to understand the 14th Amendment. You cannot understand the 14th Amendment unless you understand Barron versus Baltimore as a background here. These are natural rights, everybody has them, they have them against all governments, but with respect to the Bill of Rights in particular, you can't go to federal court to have your rights protected against the states. Now, let us fast forward now to the Civil War. After the Civil War, when the Republicans in Congress are struggling to protect the newly freed slaves in the South from the black codes that Southern states had adopted to reestablish white domination, and you have absolutely no idea the relentlessness with which the Southern states after the Civil War were attempting to reestablish all of their old institutions in all ways short of calling these institutions slavery. In 1866, the Republicans in Congress enacted the first Civil Rights Act. Now, in the act, after it begins by defining U.S. citizens as all persons born in the United States and not subject to any foreign power, which you will recognize as very similar language to the first sentence of what came to be the 14th Amendment, it then mandated that such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, shall have the same right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens, any law, statute, ordinance, regulation, or custom to the contrary notwithstanding. So notice here how Congress is identifying the civil rights of all persons, whether white or black, as the rights, quote, to make and enforce contracts, to inherit, purchase, sell, hold, convey real and personal property. In other words, at the very core of civil rights were the economic rights of contract and property. And by the way, this is where contract comes into the picture. All the previous definitions of natural rights I talked about referred to property, didn't refer to contract, although the Contracts Clause did. So at the very core of civil rights are these economic liberties, though characterizing these rights as economic is anachronistic. It's using our category scheme imposed on them. So now we have to ask, what did Congress think empowered it to enact the Civil Rights Act, protecting the economic rights of contract and property against infringement by the states? What do they think gave it the power to do that? And for many of you, I think, it will come as a surprise that the answer was the 13th Amendment. The first section of which reads, "Neither slavery nor involuntary servitude except as punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or in any place subject to their jurisdiction." That's what they, and then the second section of the 13th Amendment gives Congress the power to enforce this article by appropriate legislation. So that was the power they thought they were exercising in passing the Civil Rights Act that protects the right of property and contract. Now today, the claim that the 13th Amendment empowered Congress to protect the rights of property and contract from infringement by states seems strained. But this is largely, I think, because we've accepted the Reconstruction era Supreme Court's interpretation of the 13th Amendment, which you're going to see introduced very shortly. And secondly, because we've somewhat forgotten, or we take for granted, the injustice of slavery. Now, we've taken this injustice for granted. So too, in some respects, did the founders who wrote the original Constitution take the injustice for slavery, of slavery for granted, which is not something that emphasized in law school. The founders, pretty much to a person with respect to those who wrote the Constitution, realized that their invocation in the Declaration of Independence of the inalienable rights to life, liberty, and the pursuit of happiness was fundamentally inconsistent with the institution of chattel slavery. Now, what they thought they could do about it, what they wanted to do about it, how much they could do about it, that was another matter. But what was taken as given was slavery was unjust and wrong, and either was on a path to extinction or needed to be put on a path to extinction, and they didn't exactly know what to do about it. And we could talk more about that in the question-answer period. But there was this universal consensus. One of the reasons why we've lost knowledge of this universal consensus is because it did not hold. Things changed. We tend to think of progress as an unbroken line in one direction, but that's not what happened here. We have a consensus among the founders that slavery is wrong, and then that consensus breaks down. What caused that consensus to break down later? What caused it, most instrumentally, many historians think, is an invention. It's the invention of the cotton gin in 1794, 5 years after the Constitution was enacted. Because what the cotton gin, prior to the invention of the cotton gin, the institution of slavery, plantation farming using slaves, was a relatively inefficient form of agriculture, one in which people were not doing very well, one in which you could easily imagine that this form of agriculture would be displaced by other forms of agriculture. But with the invention of the cotton gin, slavery, plantation farming using slaves became enormously profitable. What was problematic about raising cotton using slaves was you not only had to raise the cotton and pick the cotton, but you had to separate the cotton from the sticky seeds before you could send it. You had to separate the fiber from the sticky seeds before you could send it to market, and that was an extraordinarily labor-intensive and slow process. What the cotton gin did is it mechanically separated the seeds from the fiber, and that meant you could grow a lot more cotton and you could pick a lot more cotton, and you didn't have to worry so much about the seed separation. And at that point, plantation farming using slavery became incredibly profitable. And then, as you might imagine, what would happen in a situation like that, it was at that point, for the first time in American history, that there developed a very rabid ideology in favor of having slavery, in which slavery was defended not as an evil that we don't know how, that we're stuck with and we don't know how to do away with, but actually as a positive good. And ultimately, these arguments led some Southerners, to repudiate the Declaration of Independence, where they said that it just was obviously false on its face that all men were created equal, and it was not something that should or could be accepted. So they knew the Southerners knew that it was inconsistent with the Declaration of Independence, and they ultimately chose slavery over the Declaration of Independence. Well, at the same time, you have this rise of Southern pro-slavery ideology for the first time. The abolitionist ideology gets amped up a lot, too. There had always been abolitionists. Many of the founders were members of abolitionist societies of various kinds. But Now they're amping up their argument to correspond to the amping up of the Southerners' argument. And I'm not claiming any causality here. I don't really know which came first, but they are happening basically at the same time. And what the abolitionists, although the abolitionists made many, many different arguments, at the core of the abolitionist argument was the idea of natural rights. In particular, the right of property that each person had in him or herself, which they referred to as self-ownership, which actually, that comes from John Locke. John Locke included in his second treatise of government the idea of self-ownership, or what he said, the property everyone has in himself. And they combined that with the liberty of each person to exchange his or her labor for wages and other mutually agreeable terms, which they eventually called free labor. So you had self-ownership and free labor. In fact, free labor became a clarion call of the abolitionist movement to the degree that during the 1856 presidential campaign, the Republican candidate, James Fremont, his campaign slogan was "Free soil, free labor, Fremont." That was the campaign slogan. So free labor was right up there. Now, today we would think of ownership of property and labor as economic rights. And the fact that we do really should not be surprising, because after all, if you think about it, slavery was first and foremost an economic system that was designed to deprive slaves of their economic rights. The key to slavery is labor. Any restriction imposed on what we would consider to be personal liberties by the slave power, such as example as those prohibitions prohibiting slaves from learning how to read, or prohibiting abolitionists from favoring abolitionists in the South. Advocacy of abolitionism was a criminal offense in the southern states. Whether you were white or black, it didn't matter. These interferences on personal liberties were instrumental means to the preservation of the economic system of slavery. The fundamental, and also means to establishing the restrictions on blacks' personal liberties was a way of establishing or demonstrating their inferiority, preserving their alleged inferiority, so as to further justify slavery as a positive good. The fundamental divide between the slave power and abolitionists concerned property and contract. Could a person be owned as property and be denied the right to refrain from laboring except on terms contractually agreed upon? Or did every person own him or herself, with the inherent right to enter into contracts by which they could acquire property in return? Therefore, by abolishing slavery, the 13th Amendment, ipso facto, empowered Congress to protect the economic liberties that slavery had for so long denied. In particular, quoting the Civil Rights Bill, the right to make and enforce contracts, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property. This defense of the constitutionality of the Civil Rights Act under the 13th Amendment can be simplified as follows. The 13th Amendment abolished slavery, and the opposite of slavery is liberty. So any unwarranted restrictions on liberty are simply partial incidents of slavery. If you have slavery over here, you have liberty over there, and then you start imposing restrictions on liberty, you're moving the person back in the direction of slavery. These are just partial forms of slavery. And therefore, under this reasoning, Section 2 of the 13th Amendment gives Congress the power to enact the Civil Rights Act. So, what happened next? To the dismay of Republicans, President Andrew Johnson vetoed the Civil Rights Act. Johnson was a Democrat from Tennessee, a racist, a slavery sympathizer, but he was a war Democrat, so he supported the Union. And for that reason, Lincoln put him on his ticket because the effort was to keep the Union together in order to wage the Civil War. He became president upon Lincoln's assassination. He, by the way, is a disgusting guy, and he deserves to rank at the top of every poll of the worst presidents of the United States, but it's shocking that he doesn't. But he should. Just read his veto message of the Civil Rights Act to give you some idea of why he's so bad. The whole first part of it is a racist critique of the policy of the bill, which he says attempts to fix by federal law, quote, a perfect equality of the white and black races in every state of the Union, unquote. But then he goes on to talk about the constitutionality of the bill, and with respect to the civil rights enumerated in the bill, he then offers the following reply. Hitherto, every subject embraced in the enumeration of rights contained in this bill has been considered as exclusively belonging to the states. They all relate to the internal police and economy of the respective states. They are matters which in each state concern the domestic condition of its people, varying in each according to its own peculiar circumstances and the safety and well-being of its own citizens. So Johnson's not denying these are rights. He's saying these are rights that belong to the states to regulate. He then denies that the protection of these rights is properly incident to the 13th Amendment. Slavery, he says, has been abolished, and at present nowhere exists within the jurisdiction of the United States. Nor has it been, nor is it likely there ever will be any attempt to revive it by the people of the states. This limited view of what the 13th Amendment is about and what it does came to be the view accepted by the Supreme Court, and I think is largely the view accepted to this day. Johnson's view in vetoing this act. Now, although Johnson conceded that the Civil Rights Act enumerated in the bill are, quote, by federal law, federal as well as state laws secured to all domiciled aliens and foreigners even before the completion of the process of naturalization. In other words, these are rights that everybody has. That's how fundamental they are. He concedes that. He doesn't deny it. He then says, nevertheless, that the claim of constitutional power, of congressional power, quote, must sap and destroy our federative system of limited powers and break down the barriers which preserve the rights of the states. It is another step, or rather stride, towards centralization and the concentration of all legislative powers in the national government. So in other words, he makes a pure states' rights argument. Now, how do the Republicans in Congress respond to this veto? Supermajorities in both the House and the Senate override the president's veto. And until I was doing the research for the book I'm currently working on that this speech is based on, I did not know that this was the first time in American history that Congress overrode a presidential veto, the Civil Rights Bill, the Republicans in Congress. Now, what about the 14th Amendment? It's often claimed that, is that me doing that? It sounds bad, whatever it is. Okay. Okay. Although it's often claimed that Congress then enacted the 14th Amendment to, quote, constitutionalize, unquote, the Civil Rights Act, even though there's some truth to this, it's best an oversimplification of what actually happened. So now I want to talk about the relationship of the 14th Amendment with the Civil Rights Act. The initiative in Congress to protect the rights of free blacks and Republicans in the South, and by the way, Republicans in Congress were very concerned about protecting Republicans in the South, white Republicans in the South, by means of a constitutional amendment, had begun even before the introduction of the Civil Rights Act. And it was promoted by different members of different bodies. So while Senator Lyman Trumbull of Illinois devised and promoted the Civil Rights Act in the Senate, under the auspices of the 13th Amendment, Representative John Bingham of Ohio in the House was the moving force behind having a 14th Amendment or something like it. And the scope of the provisions are obviously different. Whereas the text of the Civil Rights Act was limited to the protection of the civil rights it listed, which I read to you, the 14th Amendment protects a broader category called privileges or immunities of citizens of the United States. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Whereas the Civil Rights Act protected these fundamental rights only against discrimination, that blacks should be given the same rights as white people enjoy. That's how the Civil Rights Act was worded. The 14th Amendment did not adopt the Act's anti-discrimination language, although previous versions prior to the enacted version of the 14th Amendment were written in an anti-discrimination form. Those versions were rejected in favor of this wording, which protects the privileges or immunities of any citizen, whether white or black, male or female, from any abridgment whatsoever, not merely from discrimination. It's a violation of the 14th Amendment if everybody's privileges or immunities are taken away from them equally. Moreover, the goal of the 14th Amendment was far more ambitious than that of the Civil Rights Act. Because the southern states were eventually going to resume their seats in Congress, think about that. The southern states had tried to leave the Union. They were told they could not leave the Union. So what's the next thing going to happen? They're coming back. And when they come back, they're going to have greater representation than they had before. Because the blacks in southern states are now not going to count 3/5 of a person for purposes of representation and apportionment. They're going to count full persons. And now southern states, who were creating all kinds of problems before the Civil War, are going to have increased power to create problems after the Civil War, and they were bound and determined to do so. They basically said, you want us back? Okay, you've got us back. And we're going to continue the Civil War our goals of the Civil War, but we're going to continue it now in Congress. So they know these guys are coming back. Therefore, the Republicans in Congress wanted to put something in the Constitution that A, couldn't be repealed by the Congress when these guys got back, and B, could be enforced in the courts, because obviously Congress itself could not be trusted to be in Republican hands forever. All right, moreover, the privileges or immunities of citizens to which the 14th Amendment refers were not limited to the natural rights enumerated in the Civil Rights Act, which I read to you. They also included the personal rights of American citizens enumerated in the Bill of Rights. In other words, they included not only those background fundamental rights, property and contract, but also rights in the Bill of Rights. Now, the evidence for this is very overwhelming. It's now the new consensus amongst scholars of the 14th Amendment that the privileges or immunities of citizens included the Bill of Rights. I'm just going to read you one piece of evidence to show you what the kind of evidence there is that's out there, and it's a speech by Senator Jacob Howard of New York, who was the sponsor of the 14th Amendment in the Senate. And when asked to explain what the privileges or immunities of citizens of the United States were, he basically said they came in two categories. The first category were the rights to which the Privileges and Immunities Clause of Article 4 referred. So there is a Privileges and Immunities Clause in Article 4. And that clause, as you may know, it's called the Comity Clause. That clause basically says that out-of-staters cannot be discriminated against when they move into another state. But since there are benefits that out-of-staters can't get and in-staters can get, like reduced tuition benefits at schools, let's say, there has to be a distinction between the fundamental rights that people can't be discriminated against about and other things. So those fundamental rights are the privileges or immunities of citizens of the United States, and there is a famous case called Corfield versus Coryell, in which Justice Bushrod Washington, who was George Washington's nephew, gave an opinion about what these privileges and immunities of citizens of the United States were. Now, this is a circuit court case, but in those days, justices wrote circuit court opinions, and those circuit court opinions were considered to be really important law, and oftentimes things did not get taken up to the Supreme Court kind of en banc by the Supreme Court when the lower courts ruled in this way. So here's what Justice Bushrod Washington said in Corfield versus Coryell about what the privileges and immunities of citizens of the United States. I can't read you the whole thing because it's too long, but this passage is really important not only because of what it says, and that Jacob Howard quotes it, but that many, many people in Congress quote it as well, and ultimately you'll see it gets quoted by the Supreme Court in the Slaughterhouse Cases too. And here's what he says. What these fundamental principles are, it would perhaps be more tedious than difficult to enumerate. They may, however, be all comprehended under the following general heads: protection by the government, the enjoyment of life and liberty, and the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole. So what you see here is Justice Washington invoking the canonical description of natural rights that I just read you repeated examples from state constitutions earlier. That's what the privileges and immunities of citizens were. But to these, Senator Howard added, they were also including the Bill of Rights. The Bill of Rights were also among the privileges or immunities. To these privileges and immunities, whatever they may be, to these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. So the privileges or immunities clause of the 14th Amendment refer to these natural rights plus the Bill of Rights. Well then, if that's true, if the rights to which Article 4 applies already in the Constitution and the Bill of Rights, which is already in the Constitution, why add a 14th Amendment? Because of Barron versus Baltimore. Because, as Howard explained, the courts that these privileges, immunities, rights, thus guaranteed by the Constitution or recognized by it, do not operate in the slightest degree as a restraint or prohibition on state legislation. Therefore, you have to have a constitutional amendment to make these rights apply to the states in federal court. So then what happened? Well, what the Republicans in Congress giveth, the Supreme Court taketh away. And in the Slaughterhouse Cases, how many of you have heard of the Slaughterhouse Cases? In the Slaughterhouse Cases, by a vote of 5-4, the Supreme Court effectively guts the Privileges or Immunities Clause by limiting its scope to purely national rights, such as the right of a citizen to be protected while traveling on the high seas. Important rights like that. I guess it's important if you're traveling on the high seas. It also adopts President Andrew Johnson's narrow reading of the 13th Amendment. Now, here's one of the key things about why they did it. How did they do it? when Miller gets to the point of saying, what are the privileges or immunities of citizens, what does he rely on? He relies on Corfield versus Corio, because that's what everybody relied on. That was just the way you explain what privileges and immunities of citizens were. He says, but then after he quotes from Corfield, here's what Justice Miller says next. Was it the purpose of the 14th Amendment, by the simple declaration that no state should make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, to transfer the security and protection of all the civil rights we have just mentioned from the states to the federal government? No, he says, he answers, because the consequences of that interpretation are, quote, so serious, so far-reaching and pervading, so great a departure from the structure and spirit of our institutions, that we are convinced that no such result were intended by the Congress which proposed these amendments, nor by the legislatures of the states which ratified them, unquote. Never mind that this very same passage of Corfield was repeatedly introduced into the congressional record as an example of what the 14th Amendment did apply to. The Supreme Court says otherwise, and I think they said so knowingly. The dissenters in the court, for example, pointed this out. The dissenters knew it was a 5-4 decision. And essentially the case is the 14th Amendment ends up getting altered and these rights getting eliminated. Okay, so let's fast forward now to the Lochner era. Does it now make sense to think that the 14th Amendment protects economic liberties of contract and property in light of the rights that were mentioned in the Civil Rights Act, in light of the reason why the Civil Rights Act was passed, in light of the reason why the 14th Amendment was passed, that that's what the word privileges or immunities of citizens of the United States includes? I think it is plausible. However, that doesn't mean that these rights cannot be regulated. That does not mean that with respect to these rights, government may do nothing with respect to them. And to show you that, let me just quote you one passage from a Lochner Era case, Meyer versus Nebraska, which is still considered, by the way, today to be good law, in which they both lay out their entire freedom of contract, liberty of contract jurisprudence, and then they say the following. The established doctrine is that this liberty may not be interfered with, under the guise of protecting the public interest by legislative action which is arbitrary or without reasonable relation to some purpose within the competency of the state to effect. Determination of by the legislature of what constitutes proper exercise of police power is not final or conclusive, but subject to supervision by courts. That's the Lochner court speaking, not in Lochner itself, but that era court speaking. So it means that these liberties can be reasonably regulated, but when there is regulation or prohibition of these liberties, the government's going to have to justify what it's doing as reasonable. It has to bear a reasonable relationship to the police power that it has if it's the states, or the enumerated powers it has if it's the federal government. And then courts have to be able to decide, pass upon the fact of whether they were acting, using their power reasonably, or in fact whether they were acting pretextually in order to accomplish some purpose that is really outside their purview. Okay, so let me conclude here. Because what I'm about to talk about a little bit, just in my conclusion, is really what got me started in this project, and that is my interest in the abolitionist constitutional writers that we today have completely forgotten. Some few historians know about these folks, but we in the law schools know nothing about them. In the 1840s and 1850s, abolitionist lawyers such as Lysander Spooner, William Goodell, Theodore Dwight Weld, James Burney, Joel Tiffany, and non-lawyer Frederick Douglass published books and articles condemning the unconstitutionality of laws sanctioning slavery, such as the Fugitive Slave Acts. They argued that these laws ran afoul of the privileges or immunities clause of Article 4, that was one of their theories, the due process clause of the Fifth Amendment, that was another one of their theories, and the duty of protection that every government owed citizens from whom they demanded obedience. So you had privileged immunities, due process, and protection. In 1859, John Bingham, member of the House then, used all three of these arguments to oppose the admission of Oregon as a state because the Oregon Constitution forbade blacks from entering or residing there. And in 1866 then, Bingham drafts Section 1 of the 14th Amendment. He's responsible for the drafting of Section 1, minus the citizenship clause, which gets added in Congress itself, expressly incorporating these three abolitionist theories into Section 1 of the 14th Amendment. By eliminating one of these provisions and distorting the meaning of the other two, along with ignoring the original meaning of the Ninth Amendment, the Supreme Court has deprived Americans of these expressed protections of all their natural rights, including the right to make and enforce contracts and to inherit, purchase, sell, lease, hold, and convey real and personal property. Thanks to the foresight of James Madison, who authored and devised the Ninth Amendment, and John Bingham, who devised Section 1 of the 14th Amendment, these protections of our natural rights remain an important part of our Constitution of the United States. They can be denied and they can be disparaged, but they have not been repealed. Thanks. Okay, those of you who have stayed have been very patient. I know this is a big time lecture here. So, it's heavy. So it's not light and happy. I'm prepared to answer comments or take comments or questions that you may have. Yes.
So, basically, do you think the law at issue in Lochner was an unreasonable curtailment of the freedom of contract? I mean, do you think the minimum wage law was just arbitrary and unreasonable?
Well, it was a maximum hours law, and it's okay. But I mean, let me just tell you one little fact about Lochner that gets cut out of the casebook. So there's no way that you know what I'm about to tell you. I don't expect you to. It's in my case.
Nothing gets cut out of
Oh, okay. Well, anyway, then you must know that the Bake Shop Act was a very long and elaborate and detailed act regulating the health and safety of bake shops. You must know that it included, for example, injunctions about whitewashing the floor walls, cleaning the floors, what kind of ventilation there should be, what kind of toilet facilities there should be. It was very elaborate. And the reason why is because bake shops were located in the basements of residential buildings in congested cities. That's where bread had to be baked where it was eaten, which is right there. So it was a very hot, and involved the use of very hot and dangerous furnaces. So it was a very elaborate safety regulation. And here's the point. None of those regulations were challenged. They were all assumed to be constitutional. Only one provision gets challenged, the maximum hours law. Now, I think the court was being realistic in a way. For example, in Plessy versus Ferguson, they were being completely unrealistic about. I mean, in Plessy, they evaluate the segregation of railroad cars without thinking about what the context with which that law originated. They just didn't want to even talk about that. But in Lochner, they did evaluate the law in light of what the context was. And the context was, this was a law, this was a provision that was supported by labor unions. It was something labor unions wanted. In fact, the whole act was moved by labor unions. Kind of one of the interesting little facts about Lochner is that the president of the Bake Shop Union, who was one of the principal promoters of the act, ended up being dismissed from the union and ended up being, he was also a lawyer, he ended up representing Joseph Lochner and challenging the act all the way up to the Supreme Court. I mean, it's like one of these weird facts that is so interesting, it's amazing that we don't all know that. So anyway, so this was the only thing that gets challenged. Why? Well, because they're suspicious of it. Because they think this is really a pro-labor act, and it's not a health and safety law. Health and safety laws are okay. That's what the rest of the act was about. And then they asked, well, what conceivable health and safety rationale does it have? And they found it really doesn't have any. They said, look, if this has a health and safety law, then what about not letting lawyers work too much? How would you like it, by the way, if they passed a law that said when you became into the practice of law, you couldn't work more than 40 hours a week in the practice of law? Now, some of you might say, yeah, I really like that a lot. And then also, you're going to get paid $60,000 a year. Well, I'm not going to like that part. So wait a second, I should be able to decide how many hours a week I want to work in order to make the more money. That's an infringement, right? Well, what's a health and safety thing? It's not healthy for you to work that long. Anyway, they just thought that the connection between health and safety was tenuous. I think it was pretty tenuous.
I wanted to ask about the beginning part of your argument. I just want to make sure that I understand the principles that you're using. So, you spoke about the fact that substantive due process in and of itself can't be incorrect because we think that as it was used in Griswold and Roe versus Wade, most professors and most literature seems to think that that's okay. There were a number of people within the Lochner era who also thought that that was okay in the context of the time. Just because we think it's okay for privacy does not necessarily make it right. So what is the reasoning for I'm thinking that you have a lot more behind that I just didn't get, and I'd love to.
Well, that was all part of my opening kind of setup, which is basically saying it used to be thought to be very bad, and now it's only thought to be bad. And so the question is there some basis for substantive due process? I mean, is what you're asking me, and let me just say, try to make two quick points about that. One is that the analysis that I've given you up to now suggests that the problem with substantive due process is you're looking at the wrong clause. That you should really be looking at the privileges or immunities clause and not the due process clause to protect these substantive rights. And the reason why the court didn't is because they had Slaughterhouse as a precedent, and so when they came time to protect substantive rights, when the minority of Slaughterhouse became the majority, and also when it became clear that blacks were not necessarily going to be the beneficiaries of all this stuff, then they were much more ready to use these 14th Amendment to protect rights. When they did that, they used the due process clause, which was what was left to them. So it's a shifting of the clauses. Now that's one way, that's sort of how I've argued in my book, Restoring the Lost Constitution. You've looked at the wrong clause. Now, I'm not entirely convinced, however, that the due process clause doesn't itself have a substantive dimension to it. And I just don't know the answer to this, whether it does or whether it doesn't. I haven't seen any evidence for it yet in the evidence I've looked at, but I haven't looked at all the evidence in the course of what I'm doing now. But I will say this, it is not a ridiculous concept to think that it does. It seems contradictory, substantive due process. How is that possible? Well, as soon as you just do this to it, it becomes really obvious, it becomes really natural. What if the due process of law includes judicial review to evaluate whether a particular law is within or without the power of the legislature to enact it? What if that is part of the due process of law? The due process of law includes judicial review. That's a process. And judicial review to see whether the act passed was within the scope of the jurisdiction of the legislature that passed it. Then you get what's called substantive due process, but it's really not. It's part of the process of law to have that happen. That, I believe, is how the Supreme Court consciously thought of the due process clause during the Lochner era. When they were using the due process clause, that's why they thought they were talking about due process. It's part of the process of law. In fact, that's how the New Deal court thought of it. In Caroline Products, one of the things that is forgotten, because it's cut out of the casebooks, but of course it wouldn't be cut out of Professor Young's teaching materials, is that after footnote 4, which says the presumption of constitutionality can be rebutted by the 3 categories in footnote 4. Have you guys had Caroline Products? Well, then you must know that in the text of the opinion following that, the court also says that it would violate due process. It would be a violation of due process to prevent somebody from going into court to show that a particular statute was irrational and arbitrary as applied to it, to that person, or to show that times had changed. So a statute that had formerly been reasonable is no longer reasonable. It would violate due process if someone could not go into court to do that. Well, that's not the law today. What happened to change that? What happened to change that is Williamson v. Lay Optical. Because the lower court in Williamson v. Lay Optical followed that lead and allowed people to challenge laws as irrational and arbitrary as applied to them, and in fact they were in that case. And then the Supreme Court said, no, that's not what we mean. What we mean is if we can imagine a possible reason why a legislature might have adopted it, that's good enough for us. You can't come in and challenge a law for that. So even the New Deal court felt the due process clause included scrutiny to make sure that a law was actually fulfilling one of the appropriate powers that are exercised within what they would call within the competency of the legislature that's enacting it. So all of that, I think, is possible. I just haven't seen any evidence yet that surrounding the 14th Amendment, that when they used the term due process of law in the 14th Amendment, they had that in mind, or that what I really don't want, when I do originalism, I'm not asking whether they had that in mind. What I'm asking is, did that have that meaning to the public? Was the public meaning of due process of law, did that include judicial review for unreasonableness of this kind? And I just haven't seen that evidence yet, but I'm still on the lookout for it. Did you have more? Okay. Yes.
2 things. First, on a factual basis, I think the first veto overridden was Tyler, not Johnson, with the Civil Rights Act. It seemed right to me, and I double-checked it online.
Really? Well, thank you. You mean I have to stop saying that?
I get you can still say it. It just
it wouldn't be true. Well, I get this from a history book. I get this from somebody's book. I didn't make it up. So.
Second question is that you talked about how under your vision of going back to the Lochner Era.
You have no idea how distressing this is to me, because I love saying that. Okay.
Probably wireless access.
Yeah.
Going back to Lochner, did you think a lot of...
Can I ask you a question, because I'm really interested in this? What act was what act did Tyler veto?
It was a tariff. It was a bill dealing with revenue cutters that got overridden just when he was heading out of office.
Really? Okay. Now I'm gonna. I have an idea where I got this from. I know who he is.
Right.
So I'm gonna have to.
In terms of what you think, in terms of that legislation that you thought needs to be more tightly constricted, does restrict all legislation dealing with economic liberties. What legislation over the past 75 years you think is an undue restriction and would be turned back under your view of Lochner?
You mean apart from having Timothy Geithner run the entire country? No, that's actually an enumerated powers question. That's not.
Going straight through to Civil Rights Act, Wagner Act, dealing with OSHA, dealing with the EPA.
Yeah, I just, first, I tend, I tend not to answer questions like that because and I'll tell you why. Because, and it's the same, really, the Bake Shop Act is a good example of that. You would need to know quite a bit. Let's take the Bake Shop Act, for example. You need to know quite a bit about the bake shop industry and what the state of the evidence is and what the relationship is between what's being done and what the power is that's allegedly being exercised. And you really need to know a lot about the facts to decide whether an act violates. Under the approach that I advocate, you need to know a lot about the facts because what you're looking for is a reasonable relationship of means to ends. So you have to ask what the ends are, and then you ask what the means were. And that's a considerably fact-based enterprise, and it's contextual to the particular statute you have in mind. Well, no, I'm not going to do that. I'm just telling you that opinions like this have to be knowledgeably expressed. And at the moment, I'm not thinking of a statute that I have thought about like that, so that I can give. I'd be happy to give you the bottom line of a statute I'd thought about in that way that you've suggested, but I can't think of one at the moment that I've thought about that way. So I just can't answer the question. Okay. I would answer the question if I could, but at this moment I can't think of I'm sure there are lots of acts. I'm sure there are, but for one thing, I'm going to have to disaggregate things that are enumerated powers cases from things that are due process clause cases because they have an unreasonable fit. Here, I'll give you an example. I have an example. Raich versus Gonzalez. We had a due process clause challenge as part of our challenge. After we lost the Commerce Clause case, we were on remand to the Ninth Circuit and we asserted a liberty claim under the Due Process Clause. And we said that the Controlled Substance Act was irrational as applied to Angel Raich, who was trying to preserve her life by means of using medical cannabis pursuant to state law. So there you have it. I fully believe in good faith that even if the Controlled Substance Act is within the power of Congress to act under the Commerce Clause, which I believe it is not, or potentially not, but that wasn't at issue now. What I do think is, as applied to women in Angel's position, the act was unconstitutional as applied to her. So there you have. There's an example I have thought a lot about. And it just popped into my head. In fact, I litigated it and then lost in the Ninth Circuit. And I lost in the Ninth Circuit because under today's Due Process Clause challenge, I'm not allowed just to make that argument. What I have to do is, before I'm allowed to make that argument, I have to prove the right she's exercising is a fundamental right. That's the threshold that has to be passed before I even get to the point of getting into the discussion you and I are having. And I alleged in the litigation that the right that was at issue was her right to preserve her life, which I thought was a fundamental right, implicit in the concept of ordered liberty even. And the government argued that the right being asserted was the right to use cannabis for medical purposes, which they argued was not a fundamental right. And when the court decided that it was not the court decided that that was the right that was at issue and it was not a fundamental right, I never got to get into the issue of means ends fit at all. Current law prevents me from getting into that, prevents any of us from getting into it, unless you identify the right first as fundamental, and then they have a doctrine in which they pretty much can deny any rights claim as fundamental if they want to, simply by defining it at the level of specificity such that it can no longer be credibly claimed to be deeply rooted in the nation's tradition and history and implicit in the concept of ordered liberty. All right, thanks very much.